Is the COVID shutdown constitutional? Can we jail a salon owner over it? I think we could be reasonable about that. I appreciate you joining me today. Just know that I was recording this with green screen, trying to make it fancy, and my lights went out. My lighting went out, and so you will see some switch back and forth. I'm so sorry. I know it's distracting. Thanks for sticking with me. It won't change, but I'm not recording this again. I just don't have time to record double of every video and then edit it. So thanks, guys, and I hope you enjoy it. Hey, guys, your favorite lawyer, Seth Fuller here, in my beautiful green screen office with the beautiful books. As you can see, lots of books. I've read all of them. Nice seeing y'all. Wanted to talk about another topic. I've been super busy lately. I appreciate all your support, and I wanted to talk about one more topic that seems to be on everybody's mind. Of course, COVID and the COVID shutdown and all the executive orders are. And recently there was a salon owner in Texas who's gained nationwide notoriety for being arrested for refusing to comply with these shutdown orders and opening her salon early. So I'm going to discuss all that and what that means. But first, we got to start at the basics, which is the legality, how a shutdown works, how it's legal, and what that means. So if you don't know, you have the constitutional right to freedom. You have the constitutional right to assemble. You have the constitutional right to due process before they take any of your property or take any of your business. You have a lot of constitutional rights that essentially says that if the government doesn't have a good reason to jail you, like you hurt somebody or broke a law that hurt somebody, that they can't lock you in a box for that, and they can't shut down your business, and they can't do anything that infringes on any of your freedoms unless they have a good reason. Now, of course, we have good reasons for most of the laws we do, murder, assaults, theft. Very good reason. There's some questionable ones, drug possession, but still, all of those have been run through the legislature. We have voted on them. We have voted on the people that have voted on them. And supposedly, if you believe that it's working, then those laws are for sure constitutional and only infringe as much as they have to. All right. You also have licensing laws, like who can cut hair and who can be a lawyer. I bet you wish they had license laws of who could get on here on YouTube. I might not be there, but they have lots of licensing laws. And again, those have been run through the constitutionality. They're very limited. Unless you want to cut hair or unless you want to be a lawyer, you don't have to follow them, and they don't apply to you. So all of these laws are generally in effect, and we go about our day and we all know about them. Well, along comes an outbreak, and one that we haven't seen for nearly 100 years, if not more than 100 years. And so immediately the government scrambles because this outbreak is killing people. In doing so, the government has previously enacted laws that are not supposed to infringe on your constitutional rights, but are supposed to allow the government to protect the public, okay? And the first one of these is called the Texas Disaster Act of 1975. The purposes of this is to reduce the vulnerability of people and communities of the state to damage, injury, and loss of life and property resulting from natural or man-made catastrophes, riots, or hostile military or paramilitary actions. So basically, we do want to give the governor in this case, because this is a Texas law. I'm not going to go over the federal law because that would take forever, and it's something I'm not too familiar with. I am familiar with this. And in Texas, it gives the governor the power to do certain things in case of emergency, in case of a disaster. Now, most of these things in the Texas Disaster Act is geared towards a flood, rioting, earthquake, tornado, all of these things that can create, like the flood in Houston, all of these things can create massive problems that the government needs special powers to apply, and the Disaster Act assumably gives them just the amount of powers, and not anymore, to go about their business and protect the public and protect the public's property, and basically just make sure everything's taken care of during this disaster. Now, this doesn't cover everything, and so we have another law, another statute. It's called the Communicable Disease Prevention and Control Act. Say that 5 times fast. So basically it says the state has the duty to protect the public health, which we all want, and each person shall act responsibly to prevent and control communicable disease. And it goes on to define them and everything. And so this is what gives the power to the other act we talked about. This is pretty much takes that and applies it to communicable disease. Now, here's the thing. If you go through this, almost every law in this, which is Chapter 81 of the Health and Safety Code, almost every law in here applies to people who have assumed, or they have reason to believe, or that are infected with a communicable disease. This act essentially limits the powers to keep people in their home, to keep people from going about their business, to shut down businesses, to those that are directly related to communicable disease. In other words, people who are infected, people who have just been with people infected. In other words, they have created a bar which the state must reach in order to limit people's rights, and those rights can only be limited specifically through this act. So, how do we have a lockdown, you might ask, and you probably have asked, how do we have a lockdown if this Communicable Disease Act pretty much only talks about people who are infected? How are we locking down healthy people? And you've probably seen a lot of memes that we don't lock down healthy people, that's against the Constitution, and I'm going to address that. So we go back to the Texas Disaster Act of 1975. And in it, there is a provision that says 418.108, Section 418.108 is a declaration of a local disaster. And basically, it gives the power from the governor. We're a giant state. The governor can't do everything. So it gives some of the power to the governor to the county judges, in short. And it does so in order to make sure that everybody's safe when there's rioting, that people aren't going into your business while you're at home or away from the rioting, when there's flooding, that people aren't looting and all that. And it allows the county judge to make a law saying that you can't do that. And it's under subsection G, and it says the county judge or the mayor of a municipality may control ingress to and egress from a disaster area under the jurisdiction and authority of the county judge or mayor. And that's basically saying they can, in a disaster, they can keep people from coming in. So if it's a flooded area and you're worried about looters, you can block that off. And control the movement of persons. Now again, that's pretty loose, and you're getting to where, well, what does that mean? And then you get to the part that is directly tied to the salon and the occupancy of premises in that area. So here, under one statute, you go from a specific limited set of powers that everybody has to pretty much whatever they want to do. Control the movement of person. Control the occupancy of premises in that area. So what does this mean? Well, again, I've been trying to give you facts. I'm going to give you my opinion. This was in 1975. And we haven't had a situation like this in 1975. We've had flooding, and again, nobody cares about not being able to go to a store when the store is flooded. Nobody cares because all these things, A, are very short term, and B, are very specific to where you can go and where you can't. And C, and this is the most important part, has not been directly abused, and so it has not been come under question. Which leads us to Dallas, Texas. Well, it leads us to Texas first. Under this, both of these acts, the governor can enact certain restrictions, but the question is, how can they be enforced? And again, they can be enforced under this is an order, and each municipality can decide how it is enforced. Some are Class C misdemeanors, some decided it would be Class B misdemeanor, and those are your elected officials. And then again, we haven't had this until recently, so the question is where are the limits of this constitutional exercise of power? Where does it cross the line to unconstitutional? And so what we're seeing today, specifically with the Salon case, is the government, the people, law enforcement, all trying to figure out where the limitations of this power are, where their power starts and stops, how limited do we need to be? Which brings us to Salon Karen. This is Shelley Luther. She's a salon owner in Dallas County, Texas. Owns a plush salon. She's a well-to-do woman. And she is the center of all this controversy. Now, I want to start with this instead of ending with it, which everyone else seems to be doing. This was a concerted effort. There was a group that got with her, something Patriots, something like that, and basically they, with her, decided to test the constitutionality of these laws. Now, I get it. Everyone thinks that it's just spoiled brat doing what she does, and I want to make it clear. She is in no way, shape, or form in the realm of the freedom fighters and social justice heroes that we have before us. Anybody, I'm not even going to mention the names. You know who I'm talking about. However, it does take a certain kind of person and a certain kind of events to help us establish these limits of freedom that are so important. Make no mistake about it. These freedoms are the core of our American democracy, and they are the core of America itself. The notion of it is freedom. And so the questions posed are not easy ones. This is a once-in-a-lifetime event. This is a statute that was enacted after the last time this happened. And so these things need to be tested, and they have to be tested in certain ways. And so this group, knowing this, got with Shelley Luther and with some other supporters, and they essentially did this as a plan. So Shelley decided to keep her salon open, and she did, and the judge fined her. And so the judge, County Judge Clay Jenkins, issued an order, a stay-in-place order, that said that salons had to shut down. At some point, the governor overrode that order, basically, but the county judge said, no, I have the power to do this, and left the order in place. So here we are with Shelley. There's a temporary restraining order issued that says that, hey, the judge has issued an order, you're in violation of that order, and we are going to restrain you. It was issued by a Judge Moyes, Eric Moyes out of Dallas, a pretty well-respected African-American judge who'd been on the civil courts for, I think, over 20 years, was very stern, ruled with an iron fist in his court, and he said, you have to stop operating these salons, and he issued what he thought was a lawful temporary restraining order. Well, she disobeyed that order outright and publicly, and Mr. Moyes called her on it. Judge Moyes called her on it, called her in the courtroom. She, of course, was unapologetic. He gave her the opportunity to apologize. Then he said, you're going to jail. He sentenced her to 7 days for contempt, again, for not breaking any law, but for violating what he thought was lawful order. Now, so we're back to whether this order was lawful. And the question goes down to what I just talked about, whether the statute of 108 restricting this lady's right to have a business is something the government can do under the statutes, or whether that particular subsection that allows the county judge to control all of it can or did become so restrictive as to violate the rights and violate the nature of the Constitution. Maybe vague, so vague that you can't determine what is a violation or what not, but basically whether this subsection is good and whether it can be enforced with jail time. Now again, it's not enforced by jail time in the statute. Instead, the judge issues a temporary restraining order telling her to stop it. And if you violate a temporary restraining order, you can face jail time. You broke the law. Well, she refused to apologize, and Judge Moyes sentenced her to jail for 7 days. Now, here's the thing that I have an issue with. He can send her to jail if he thinks that the order is constitutional, that he issued a TRO under, and indeed, you cannot violate a TRO. However, my problem is Judge Moyes says in his order, it is further ordered that any time the defendant should wish to purge themselves of their contempt, they may petition this court for release from confinement. Should the defendant aver under oath that they shall immediately cease and desist the continued operation of the salon, publicly express contrition. This is the thing I have a problem with. There is no doubt what is happening here. She thinks the order is unconstitutional. He doesn't believe her. He's the judge. He gets to decide. There is no doubt about any of that. And obviously here she's acting like a spoiled brat, except for this is all planned. So I would say she's acting rationally according to their plan. And asking someone to apologize to let them out of the jail is troublesome in that it seems like that is ego ruling. But more importantly, I will just tell you, besides like parole hearings, I never see that in criminal matters. Now, my clients can apologize profusely, show that they're contrite, and try to get a reduction in sentence. But once my client is sentenced to 30 days in jail, I've never once had a judge say, come back and apologize and you can get out. That seems against it, because the apology is not what you want. You want them to comply with the law. And so saying I will comply with the law should be enough. You could easily write in here as a smart judge, if you swear that you will comply by the law. For you to say you have to show contrition, you have to show that you're sorry, is absolutely, in my opinion, unacceptable. It shows that there is ego. Judges are people too. There is ego. But in a case like this, where the constitutionality of a law is involved, I think you have to show you have clean hands. Now, here's where things start to get wacky, okay? Because soon after this, both the governor of Texas and the attorney general of Texas send a letter openly, a public letter addressed to Judge Moyes, saying basically this is not what we intended with our orders. Basically, they were saying your county orders are similar to ours, and we don't think that this should be enforced by locking people in jail who are just trying to run their business. And here's where I really think this comes from. When you have a constitutionally questionable law, the reason this law stands so long is because nobody had violated. If during a flood, a sheriff had decided that the Disaster Act means he could kick all of the poor people out of the projects even though their projects weren't flooded, and then not let them back in for a certain amount of time, obviously that would go up and almost certainly would be unconstitutional. The reason that you don't do this is because you don't want to rock the boat. Okay, the law technically, we both saw that the law might allow for that. And then it is unconstitutional. So if you have a law that is only used once in a while, that is a little bit vague, the one thing you don't want to do is rock the boat. And I really do think, aside from the politics, I'm not good with politics, that this jailing somebody rocks the boat and it calls into question the constitutionality of it. I can't tell you how rare it is for the governor and the attorney general to talk smack to a judge and say, you can't do this. It's not binding. They can't do anything about it, but they just basically were talking smack. Be aware of the impropriety of this contact. This is smack talk from the courts to the attorney general trying to put him back in his place. I mean, again, I don't follow politics, but I definitely follow smack talk. And this is so awesome and so rare that it is very intriguing. And I personally love it. But that's not where it stops at all. Because if you know anything about smack talk, you know it never ends after one exchange. But before the next exchange, the Supreme Court of Texas denies Shelley Luther's petition to have her sentence revoked, basically. But they take her writ of habeas corpus, which is basically get me out of jail, and they grant it. And they get Shelley Luther out of jail, essentially telling Judge Moyes he was dead wrong for putting her in jail. Now, I don't know whether it's because it's unfair because the Dallas judges were letting go nonviolent offenders for much worse crimes than what Shelley Luther did, or whether it's because whether there's a question of the constitutionality of the statute. I don't know, because all they said was let her out. So then Paxton, the attorney general, sends another letter and just basically says, y'all are full of it. Not only did I do what I did, I would do it again. And the Supreme Court backed me up. And he literally wrote another response saying, I didn't do anything wrong. Y'all are ridiculous and y'all are wrong. And the Supreme Court backed me up. Now what? Now, so the salon owner may still have to serve jail time. It remains to be seen. We know there's going to be more back and forth. But there's just this, it's just so interesting. Now, the most interesting thing, and the thing that I like to talk about the most, because this is what I want to get out there, is everybody thinks they have the answer. I can't tell you how many really smart people I know think the other side is dumb. Well, guess what? I'm not dumb. Just going to tell you that. I'm not uneducated in the law. So while we can have arguments about science or other stuff, I can tell you that from day one, I thought that the use of this law, as used by the governor even, but more importantly and more specifically, the law as used by the county judges was wrong. And I think the law itself gives them the power, and therefore it is unconstitutionally vague. That's what I think. It doesn't matter what I think. It matters what the Supreme Court think, but there's some indication that they agree with me. But my point is, it doesn't matter whether I'm ultimately right or not. What matters is that I'm a generally intelligent person and I have a reasonable belief about that. Now, the other side says, no, COVID is killing people, and if we didn't enact these orders, more and more people would die, and that's the point of enacting these laws, and that's what we as a citizenry want by and large, and we do not want a bigger outbreak, and we want to do what the scientists tell us to do, and that is also a reasonable interpretation. I don't think you're dumb for thinking that. I don't think you're wrong or completely off base, I should say. I think you're wrong, but I don't think you're completely off base or stupid for thinking that this subchapter is constitutional and the way they're applying it to Miss Luther is constitutional. It's a really good question. But for the patriots who are backing Miss Luther to paint the other side as stupid, whiny baby, conspiracy theorists, or for the other side who think that we should have a shelter-in-place order that people have to follow, to call the other side stupid, not understanding of science, and more importantly, not understanding of the law, both of them are wrong. Nobody knows. This science, I'm telling you, it is not for sure. But more importantly, it's not about the science. Governors and the government don't go by science. They go by law. We go by the rule of law. And every one of those laws has to be constitutional. It cannot deprive someone of their rights without due process. And that may be what's happening here. That's the debate. We have to respect both sides of that if we're going to get through this together. Everyone says, let's do this together. Well, then respect the other side. Respect that Shelley Luther, who now has almost more than $500,000 in her GoFundMe, had the Attorney General pay for her fines. Respect that she had a plan and that she reasonably thought that the laws as being applied were unconstitutional. You don't have to respect her, because I sure don't. The last thing I want to do is support some Karen who's well-to-do and is saying she needs to feed her kid. It's all a bunch of malarkey. I don't respect her for those things. I respect that there was a plan put in place to test the constitutionality of law, to make sure that people's rights were respected. All right? And she went to jail for it, and I'm fine with that too. I also respect the judge who put her in jail up until the point he wanted to make her apologize. He thinks it's constitutional. He is the judge. We are a land of laws, and you have to respect the rule of law. And if that judge translates the law as constitutional, then you have to follow it, and you'll spend 7 days in jail. But I don't think you should apologize your way out. That's the rule of law. Unless you're doing that to every other defendant who comes in, which I don't think so. Both sides have points. And here's the thing, by and large, except for the fringes, everybody just wants the best thing, and nobody knows what it is. I don't. And I want to tell you, you definitely don't. I'm sorry. I definitely don't. You definitely don't. We don't have the right answers. There is no right answers. We can't control this thing. What we can control is ourselves. And you can control how you react to others who believe differently than you. I do believe we should come together. And I do believe we should respect each other. And we should all do what's best for ourselves and our family. And we should all respect others who are trying to do the same things, even when the way they do it, we disagree with. That's the beautiful thing about America. That's the beautiful thing about our court systems. That's the beautiful thing about humanity. If you look at the numbers, what we've done so far is amazing. We didn't have to use those hospital pop-up tents. We didn't have to use any of those ships. We came together as a society, regardless of the laws and even in despite of the laws, and we helped save lives. We helped keep these hospitals and the medical staff from being overwhelmed. We did that. We're not perfect. We didn't do it perfectly, but we did that. And I'm proud of us, and I'm proud of you, every one of you out there who cares, because I think you all care. I appreciate everyone listening. The support has been crazy. I hope you're all doing well, whatever you're doing, and thanks for watching. Have a nice one, guys.
Then sang Moses and the children of Israel this song unto the Lord. before. Today, we speak to this atmosphere.